60% of immigrant households today receive some kind of welfare benefits, whether it's food stamps, housing subsidies, and things of that character. That's a very, very high number, much higher than native population. But the other thing is this, and I think this is important, that the children of illegal immigrants who are born within the geographical limits of the United States are said to be natural-born American citizens. This means that citizens are being created in the country without the consent of the nation. Listen, it is a simple fact that sovereign nations can do two things. They can control immigration. In the old days, in the early 1900s, this was a standard theme of Supreme Court cases. It is an inherent aspect of sovereignty that a nation can determine what people are allowed to come into the country and what people are not allowed to come into the country. And there are no standards. If we find people useful and beneficial to us, then we should invite them in. But it is up to the people, it is up to the nation as an aspect of sovereignty to control immigration. But it is also an even more important aspect of sovereignty that a nation can determine who becomes a citizen and who cannot become a citizen. This is crucial. And so illegal immigrants coming to the United States have children here, and they are citizens of the United States. Now, I happen to believe that this is an incorrect interpretation of the Constitution's 14th Amendment. I don't have time to give you that lecture today, but I'll be glad to give it to you on some other occasions. But I have several of my publications are on the Claremont Institute website on this issue. And I've testified before Congress several times on the issue of birthright citizenship. And the 14th Amendment simply does not sustain the idea of birthright citizenship. And so this is a very troubling aspect, that here are citizens being created with all the privileges and immunities of American citizenship without our consent. That means that to the extent that which that happens, we are no longer a sovereign nation. I think that's very, very troubling. Now, some states are trying to step into the arena to control illegal immigration. Arizona is one of them. I think there are others. There's Alabama has recently passed a stringent law, as well as Georgia, Utah, Indiana passed laws that are similar to the Arizona law. And so we have to ask ourselves the question of what is the power of the states when the federal government refuses to act or displays an indifference on the issue of illegal immigration? What powers do the states have to protect themselves? You know, just a few months ago, President Obama went to the border, looked around a bit, and he said, you know, the border's secure. The border's secure. I've been here almost an hour now, and I can see that everything's in great shape. And we shouldn't agree with those Republicans who would like to build a big canal and put crocodiles in it or alligators or whatever he said. Now we need to move on to the more important task of comprehensive immigration reform, by which, of course, he means amnesty and the whole panoply of things that belong to his understanding of comprehensive reform. I'm wondering, I was just thinking about this when we were driving down. In Article 4 of the Constitution, I'm not so sure that this is going to be a good constitutional argument, but I'll just put it out here for your consideration. Article 4 of the Constitution says that the United States shall protect the states against invasion. That's one of the obligations of the United States of America. It has an obligation to guarantee the Republican status of every state, that every state shall remain a Republican form of government, and it also has the obligation to protect the state from invasion. Well, we could say that in a way this is a kind of invasion. If the federal government is unwilling or unable to act to fulfill this constitutional responsibility, what are the state police powers? You know, we used to say that the states have certain police powers, or sometimes they're called the reserve powers. We used to say that the states have the primary responsibility for regulating the health, welfare, morals, and the safety of the people of the states. and that the federal government does indeed have primary responsibility for immigration control and refuses to do its part, can the states exert their police powers to fill the gap or to move into the vacuum? I just want to say a little bit about the Arizona case where they passed a law, very controversial, of course, that allowed the police to inquire into the immigration status of persons whom they stop if they have a reasonable suspicion to believe that they might be undocumented aliens. And of course, you all remember the outcry. It was a tremendous outcry. Well, this is a license for racial profiling, we were told. This is, as President Obama said, this is a very, very bad idea. It's bad policy. Some people even historically suggested that this might be a kind of genocide. It was an open season, we were told, to discriminate against people who looked Hispanic and so on. Reasonable suspicion. After the hullabaloo had subsided somewhat, the federal government intervened, suing the state of Arizona to enjoin the operation of that law. What did the federal government argue? That it violated equal protection of the laws, that it promoted racial discrimination or ethnic profiling? No. The only argument that the federal government gave in federal district court was that it violated the federal government's supremacy in the area of immigration. That the Constitution gives the federal government exclusive power to regulate immigration. We've already seen that that's not true. It may be true by extension from the fact that the Congress has given exclusive power to regulate naturalization. But the argument was the federal government has the power to regulate immigration, and where Arizona, the state, attempts to do that, then it's a usurpation of the supremacy of the federal government. It violates Article 6 of the Constitution, the Supremacy Clause. Now, what had happened to the reasonable suspicion, the racial profiling? That argument was dropped. Well, maybe some smart attorney in the Justice Department, I'm not aware of any, but there may be some there, told the president or the attorney general, well, wait a minute, that notion of reasonable suspicion has been in our constitutional jurisprudence since 1968, where the Supreme Court of the United States said that an officer can question on the basis of reasonable suspicion. It's something that doesn't have to amount to probable cause, and it must be something more than just a hunch. It has to be something, the court said, which is articulable, that the policeman can say, I had a reasonable suspicion based upon these factors. So it's been in our law for a long, long time. And Arizona said, we want to use that concept in trying to regulate illegal immigration. And by the way, in 1975, just 7 years after the idea of reasonable suspicion had been authorized by the Supreme Court that said, by the way, ethnicity can be one of the factors in determining reasonable suspicion. How do you like that? So ethnicity can be one of the factors. It can't be the only factor, but it can be one of the factors. And so when the federal government went to court, they were flummoxed. Well, that's not a very good argument because all of the law is against us. So they rested upon the Supremacy Clause. Now, the federal district court judge, by the way, she enjoined the operation of the law because it entrenched upon the federal government's exclusive power to regulate immigration. And here's what the judge said in the beginning of her opinion. She says, I recognize that the Arizona law was passed, I'm quoting right now, against a backdrop of rampant illegal immigration, escalating drug and human trafficking crimes, and serious public safety concerns. So here's the federal judge who is now saying that that law is unconstitutional, but admits this was the reason that the Arizona legislature passed the law and the governor signed the law was because of this rampant crime that was connected with illegal immigration. we wonder what's left of the state's police powers in the face of this kind of legal reasoning on the part of federal district court judges. Nevertheless, she said, look, we can't allow the states, this will interfere with the federal government's power to regulate immigration. Generally speaking, we say that the federal government occupies the field if state law is incompatible with the federal law. That is to say, if a state passes a law on the same subject which clashes with the federal law, then we will say that the federal law takes precedence. Or if there is some kind of policy difference, that the implementation of the laws are incompatible with federal policy, then we say that the federal law occupies the field. But in this case, there didn't seem to be any kind of conflict. And here was the state saying, we need to protect the citizens of the state of Arizona. We have the right, we have the obligation to do so. And we're going to occupy a field that had been abandoned by the federal government. But this argument was of no avail in the court, and the law was enjoined. It went to the Ninth Circuit Court of Appeals, and I suppose all of you know what the result was there. And one of the more interesting arguments that was adduced by the Ninth Circuit was, look, the federal government has exclusive power over foreign policy, and this law will interfere with foreign policy. Proof? The president of Mexico and several other Latin American countries have complained bitterly about this law. And this makes it difficult for the president and the secretary of state and other officials of the federal government to implement foreign policy. Arizona did have, however, one success, and I think that here is something that we should take note of. Arizona had another law which put rather severe sanctions on businesses or employers who hired illegal immigrants. There was a substantial fine for the first violation, and the possibility of losing a business license for the second and third violations. Now, this case was just recently decided by the Supreme Court of the United States, and here the Supreme Court upheld the law, saying that in the 1986 Immigration Control Act, there was an exemption specifically stated in the law that allowed states to retain control over licensing and other kinds of business regulation. So luckily enough, in 1986, when that law was crafted, the legislators put in that exemption. Arizona was able to benefit by that, and the Supreme Court of the United States said Arizona law is good law. And I think that this is important because I happen to believe that one of the most effective ways of dealing with illegal immigration today, not only is border control, which I strongly advocate, but strong sanctions for employers. Arizona law had those strong sanctions. Every employer had to use the federal identification system before they hired someone. And by the way, using the federal identification system exempted any employer from liability in case the system made a mistake and they accidentally hired an illegal alien, and so on and so forth. I think if there are no jobs in the country, illegal aliens will have to go home. What can they do?